Thanks, Mateus, and thank you everyone for joining us here today. My name's Stephanie Harvey. I'm a lawyer in the Gowling WLG Hamilton office, and I'm in the lending department. I'm here with my colleague today, Emma.
And as Stephanie said, my name's Emma DL. I'm an associate in the Hamilton office as well. I primarily practice in the Small Business Loans Recovery Department. We're moving through our agenda today, and we have a couple of things we want to talk to you about the pitfalls of debt recovery. We have a few topics to cover. We don't have a ton of time, so everything we discuss is going to be a very high level. If you have any questions or concerns, please feel free to put a comment in the chat box, and then we will address them as they come up. And if you want to come to our breakout question and answer session, that would also be wonderful. I'm going to hand you right back over so we can dive into it with Stephanie for deemed trusts.
All right, thank you very much, Emma. Deemed trusts are a very complex, complicated topic. As Emma mentioned, we don't have a lot of time for this presentation, so I'm going to just touch on the main points of deemed trust. And I do encourage you to stay after the presentation, ask me any questions. You can email me directly if anything comes up after the conference. So let's just dive right into what is the deemed trust and when does it arise? So generally speaking, a deemed trust is a tax collection mechanism for the Crown. It protects the Crown from a tax debtor diverting money that they owe to it to pay its other creditors. Typically, you see deemed trusts arise with respect to unremitted HST or payroll deductions. By that, I mean CPP or employment insurance. So I thought I'd give you a quick example just to show you how a deemed trust works and how it's operationalized. So let's say that I own a plumbing business. I show up at your house, I fix your sink. I charge you $100. At that moment, $113 is due to account for the $13 of HST. So now I am holding that $13 in trust for the Crown. When it becomes time for me to remit my $13 to the Crown, pursuant to whatever my pay period is, if I fail to give it to the Crown, that means the deemed trust is operationalized, so to speak, and the Crown has a deemed trust over all of the assets of my business. So what happens is, and you can see how this is unfortunate for lenders, if you have a GSA, let's say, against my company, and the Crown now has a floating charge, it's akin to a floating charge, let's call it, over my company, it now takes priority over your GSA. So now let's say I keep paying you on the GSA, your monthly payments, you're actually, as a secured creditor, collecting the Crown's money. So what happens in the end is the Crown turns around and says, hey, you lender, you owe me money. And so they turn around and what was actually my debt turns into a liability of the secured creditor lender. So I think the risk to lend to secured creditors is quite obvious. I would also like to point out how these risks are exacerbated. First of all, there's no precondition for a deemed trust to arise. And by that, I mean this. CRA does not need to register a lien on title of a property for it to exist. CRA does not need to notify a secured creditor with a GSA that a deemed trust exists. So this means that a secured creditor could be completely oblivious and not know that the deemed trust is out there, going along their way, collecting money from the tax debtor, only to have to pay it to CRA later. The next item that I would say is important for a lender to know is this. Once a deemed trust claim is made against the secured creditor because they say that you owe them money, it's a personal liability of the secured creditor. So that means that if you don't pay, you bank do not pay CRA, they can commence a claim against you now for money that you just received from your tax debtor, unbeknownst to you about the tax debt. The limitation periods make this even scarier, okay? They are either 6 to 10 years, sort of depending on the piece of legislation. So that means you could be collecting money from a tax debtor on your loan, your mortgage, your GSA for 6 years. And the Crown would have priority for that money. I do want to say, though, the one exception to this is a mortgage. So the legislation does provide some protection for a secured creditor that is a mortgage registered on title. So that means that CRA, unlike any other secured creditor with like a GSA or something, does not have absolute priority over the secured creditor. The mortgagee also, however, does not have absolute priority over CRA. So, I mean, there is protection there. They do chip away at it, like CRA does. They do chip away at it. But at least there is some sort of protection for the secured creditor with a mortgage registered on real property. So some further good news for lenders, so that I'm not too much of a downer for everyone, is this. For unremitted HST, a bankruptcy actually reverses the priority and will allow a secured creditor to leapfrog back into priority over CRA and the Crown. So what that means, it could be a voluntary assignment into bankruptcy, CCAA, it could be anything. You could petition a tax debtor into bankruptcy. And me, having done several years early in my career in debt recovery, I've actually been involved with a secured creditor who took the drastic step of putting a tax debtor into bankruptcy in order to reverse that HST priority that they were claiming over their security, and in order to get their full priority back. So it's a powerful tool. And the Supreme Court of Canada in the last couple of years has actually strengthened that position by ruling that the timing of a bankruptcy does not matter. The reversal of the priority is absolute. Title insurance. Title insurance is another good news story for the secured creditor. What I mean by that is this. Most people get title insurance. Most lenders get title insurance at the time of the mortgage. So if there's a deemed trust claim and there happen to be deemed trusts that were owing prior to the registration of the mortgage, it's covered by title insurance. The further good news is this. Until just the last couple of months, title insurance would end at the point that the mortgage is paid out, the loan is paid off. Title insurance no longer exists. I've actually had this happen where I received a deemed trust claim on behalf of a secured creditor after a mortgage was paid out in the normal course. And I went to title insurance knowing what the answer was going to be, but was told, sorry, policy's over. What would have been covered is no longer. Title insurers in the last couple of months, actually in August, they changed that policy. And so now in all residential policies, at least with the one title insurer that we work with, I should preface this, that we work largely with, all residential policies, it's automatically included. And for commercial policies, for a nominal fee, you can obtain this coverage. So since this coverage has been available in August, we've obtained it on every single commercial financing that we've done because it just provides added protection for the lender. I'm just going to end very quickly by saying, so what can a lender do to protect itself? And I know the answer is probably very little. We all know that it's difficult to get answers from CRA, et cetera. But listen, this is what you need to do. Due diligence, due diligence, due diligence. Not just at the time of the loan, but throughout the entire loan. You have to keep on top of all of your clients to make sure you're getting all of the appropriate tax information throughout the entire life of the loan. Because it's only at that point that you can feel comfort in knowing that a deemed trust claim is not going to come back at you later. So that ends my portion of the deemed trust. I'm going to turn it back over to my colleague Emma, who is going to now speak about landlord waivers and tenant estoppels.
All right, thanks, Stephanie. So we're going to dive right into landlord waivers and tenant estoppel. These are two third-party documents that are sometimes found in lending transactions. So a landlord waiver is an agreement signed by the borrower, the lender, and the landlord, whereby the landlord agrees to waive some of its key rights. As you have probably found out in your day-to-day practice when you're doing your lending, One of the primary pieces of security that a lender takes for their loans is a general security agreement or a specific security agreement over the assets of a business. Now, if your borrower operates in a leased premises, that means that the lender's security is located in a leased building. So at the time of lending, a lender probably wants to do a couple of things. They want to ensure that the lease is in good standing. They also want confirmation that the lease or the enforcement of the lease isn't going to jeopardize the lender's security in those assets that are in the leased premises. So a landlord waiver does two key things. It provides a waiver of distress and also provides an access to the collateral. So first off, with the waiver of distress, we have to understand that the landlord has a right that takes priority to a secured creditor, whereby they are able to seize and sell the assets of a business in order to satisfy rent arrears. That means that if their tenant owes them money for rent, they can seize and sell the lender's security. So when it comes down to an enforcement scenario, the lender's going to find that there is less assets remaining in the business. So the landlord waiver has an important function whereby the landlord waives that right. Another important right is the access to collateral. So obviously, if you're a lender and your security is located in this leased premises, there is obviously a risk that the landlord can make it awkward for you to get in there to inspect, appraise, or seize and sell the assets in an enforcement scenario. So a landlord waiver provides an upfront consent on this so that there's no argument at a later time that the landlord isn't going to provide a lender access so that they're able to enforce on the security. Obviously, the risks of not getting a landlord waiver are a little bit common sense. Now you know what the two key things are in a landlord waiver. One of them is the fact that the landlord might distrain on the assets. And in an enforcement scenario, a lender is going to go in and want to enforce on its security and find out that the landlord has already gone ahead and seized and sold it to satisfy rent arrears. Or the landlord's just going to make it really awkward for a lender with a security interest in those assets to get in there and seize and sell the assets. On the alternate side, we have a tenant estoppel certificate. So a tenant estoppel certificate is something you might want to consider if your borrower is a landlord themselves and they have tenants. So a tenant estoppel certificate is a document whereby the tenant makes certain representations to the lender that certain things about their lease are true. A couple of the things that might be contained in it is a copy of the lease. So it would include all documents that pertain to the lease. It would also include any grievances that the tenant has against the landlord, any rent-free periods that the tenant has, any tenant inducements that the tenant was offered, and also confirmation that the landlord has been fulfilling all of their obligations under the lease. This is important because, as you probably know, if you are a lender helping a landlord with refinancing of the commercial property, you're probably taking a collateral mortgage over the commercial property and potentially an assignment of rents. In an enforcement scenario, you want to know as much about the tenants as you can, so it's really helpful to get those leases up front because everyone is a little bit more cooperative when money is being given out and not so cooperative when people are trying to get money back. And with that, I'm going to pass you back off to Stephanie to talk about adjoining lands.
Thank you very much, Emma. I promise this topic is going to be much shorter than my last one. So when adjoining lands in the Planning Act was proposed as a potential topic for this conference, I went and I chatted with one of my real estate colleagues and I said, how do I make this topic, which has got to be very brief, interesting and engaging for the audience? Because the topic itself can sort of lag in that front. And so he suggested to me, why don't you just give them this real world example? So while it's not completely a pitfall to debt recovery, it's actually another good news story for lenders. And I think it's just an important point for everyone to understand. So first, before I get into the scenario, I thought I'd just put a little bit of background about the Planning Act. So what it is, as the name suggests, it's planning legislation, which, amongst many other things, can sometimes have the effect of causing properties to legally merge, as we say, vis-a-vis the Planning Act, if if you've purchased a budding property. So if you look at my screen at the very interesting and complex diagram that we've put up there with A and B. So if someone purchases parcel A, I purchase it, let's say, with my plumbing business, and then I purchase parcel B 10 years later. If they abut, meaning they adjoin, under certain circumstances, the Planning Act causes them to merge, meaning that if I want to now go and sell parcel A by itself, I can't just do that. I actually have to go and get consents through the Planning Act, and assuming that I'm going to get the consent, I have to spend the money and the time to do that. So that's why it's very important for your lawyers that you hire to do due diligence when they're putting mortgages on and taking transfers of property to ensure that if your borrower owns a budding property, it is known. Another important point to note is that if I purchase A and purchase B 5 years later and I try to finance, I must finance all of A and all of B and put my mortgage over both. Otherwise, the mortgage will be invalid under the Planning Act. That means that you'd have to go through a difficult process of trying to validate it, and you could run into priority issues. So while the due diligence is more on the legal side, it is still due diligence that's required just to ensure that you get your mortgage security that you're bargaining for. So the real life scenario that I just quickly wanted to get into is this. So let's say I buy parcel A and I put a mortgage on. You're my lender for my plumbing company. So now let's say the mortgage is just over part A. I go and purchase part B 5 years later, again in my example, and then I default on my loan. You as the lender didn't know that I purchased parcel B, and you don't have a mortgage over parcel B. Well, what the Planning Act actually allows you to do is this. Under a power of sale, you're able to sell parcel A and sever the property in a way that I, as the owner of the property, no longer can. So this is great news in a power of sale situation when your debt isn't being paid and now you've run into an adjoining land issue. You're still able to sell under power of sale. And the good news for lenders, as my slide suggests, is this. There is proposed legislation, it's still making its way, I think it's at first reading currently, that would strengthen this interpretation for lenders. So just make it even more evident that you'd be able to sell that property under power of sale without worrying about the fact that it had actually merged legally under the Planning Act. If you have any questions, do feel free to reach out to me after, but I hope that was very clear. And I'm just going to pass it back over to Emma.
All right, so I'm going to start talking about independent legal advice and spousal consent. So independent legal advice is pretty much what it sounds like. It is independent legal advice provided by a lawyer who is not in a conflict of interest position with the parties in the transaction. So if we have Judy, who is getting a small business loan for her business, and her spouse, John, is providing security for this loan, John won't be able to meet with Judy's lawyer. He'll have to meet with another independent lawyer. It's generally required when the party who is providing the security for the loan isn't directly benefiting from the loan or is not involved in the day-to-day business operations. So in our scenario, as John is not benefiting from the loan because it's not his business and he's not involved in the day-to-day business operations, he has to get independent legal advice. Independent legal advice mitigates the risk that Judy is forcing or unduly influencing John to provide that security for her loan. There are certain relationships where a court presumes undue influence, and if a court finds that there is undue influence, a court will actually set aside the security so that it becomes unenforceable and a lender can't rely on it in an enforcement scenario. One of the best ways to mitigate the risk of is to get independent legal advice so that your security is going to remain enforceable because they will have met with a lawyer who explained the security to them, and so they understand the repercussions if Judy isn't paying the loan. John would know exactly what the recourse available to the lender is under the guarantee. Spousal consent is consent from a spouse to deal with a matrimonial property. So in our situation, if Judy owns the property and she is living there with her spouse John, it is their matrimonial home. And if Judy now wants to provide to you as lender a collateral mortgage over her matrimonial property, John will have to consent to that. That means that he has to acknowledge that he is aware of the mortgage and consent to it being put on the property. It's generally something that comes up very frequently in residential mortgage transactions. But for our purposes, what you need to know is that it is important and something that you need to consider if you are getting a collateral mortgage on a matrimonial property and only one spouse is on title to the property. This is because under the Family Law Act, a married person cannot deal with the property without getting consent from their spouse. This is essentially to protect the property so that one party can't unilaterally dispose of it without the other party knowing. Now, the risks of getting a collateral mortgage and not obtaining the required spousal consent are great in that if the spousal consent isn't obtained, a court can set aside the mortgage, which means that it won't be enforceable and that a lender won't be able to rely on it in an enforcement scenario. And it will mean ultimately probably less recovery for the lender. So it is something that is very important in a lender's security package if they're getting a collateral mortgage on a matrimonial property. So we're going to wrap this up with some concluding remarks. So obviously, depending on the amount of the loan, you may have a lawyer who is assisting you with the transaction, and you should feel free to ask them as many questions as you would like regarding the right security for your loan. Now, if you're in the business of giving money, it's not always at top of mind to think about exactly what you need if the loan is going to go bad. But the problem is, it's the best time at the time of lending to make sure that you're getting the lender into the best position for good recovery in an enforcement scenario. So it's important to have these things to think about, and just so that you're aware of potential issues that can come up in a debt recovery scenario, so that you know that these are things that you might need to be mindful of in future lending transactions. So one of the things that we often find is you just need to make sure that your contracts are drafted well, that your security package is nice and airtight, and everything that you're supposed to get is included there. So if you're getting a collateral mortgage over a matrimonial home, you get your spousal consent. If you're getting a guarantee from a spouse and they're not involved in the day-to-day business operations, you have your independent legal advice. Because recovery files often go to litigation, and at that time you really want to make sure that there are no arguments and defenses that can be put forward where the court is often and likely to find in favor of the person providing the security, and therefore the security can be set aside. This would ultimately mean that the lender's going to get less money and they're not going to be able to recover as well on that loan. So it's always important to think about these things on the front end, even though obviously you don't want to think about the fact that potentially a loan is not always going to be a good loan. And so with that, again, if you have any questions, you can feel free to contact us at our contact information on the screen, and we can also answer any questions that you have in our question and answer breakout room.
Thank you, everyone.
Thank you.